Is it possible that there's sort of a false dichotomy problem going on here? In that I think you could imagine the test of whether Marshall's an originalist, a true originalist, is whether he only refers to the text and original intent and doesn't refer to other methods like precedent and things like that. And that seems to be what you're doing, saying sort of if you're a pluralist, if you do multiple methodologies, then you're a pluralist, and if not, if you're an originalist, just do only originalism. And I just want to make sure that we consider the possibility of an intermediate position where you might consider a lot of methodologies, but only because they are the ones that are in turn, say, original methods under the Rappaport-McGinnis approach. So if you consider text and history and structure and precedent and a few other canons of policy, because those were all themselves original methods, we might want to call that originalism. And if we needed a name for it, we might call it inclusive originalism. But I'm open to other labels because it seems like from what you say, I'm not sure we have any evidence proving that Marshall didn't do that. I mean, I think maybe it's ambiguous because he's not being clear about what the hierarchy is, but I wonder if we really know that he didn't do that. And that's also related to the sort of ipse dixit question, which is it seems like there's something special about judicial opinions actually as a method of argument. Or using the Diluted Argument, which is that judicial opinions are written not to convince but to explain. So a brief has to persuade a judge to agree. So it has to contain an argument about why you should do X over Y, and it has to sort of nail down all the parts. The judge has already made up their mind, and if they're the Supreme Court, nobody's going to overrule them. They write an opinion so that you know why they did what they did, or so that you're clear about what they chose. But they might just not explain all their choices, not because they don't have reasons, but because it's not that important for them to tell you those reasons, or because those are common knowledge. Because again, like the main point of the opinion is to make clear everybody knows what the law is going forward. So, Chief Justice Rehnquist is famous for this and maligned for this, but actually maybe he and John Marshall were sort of on the same page, and it's a mistake to read too much into it.
Mike?
So 2 points. I guess some of what I was going to say about the sort of practice of Marshall's opinions, Mike Paulson made, so I won't repeat that, but I guess what I'll add is that, Marshall tells us, that doesn't mean he follows it, but he tells us a fair bit about the hierarchy. He tells us the text is the highest point, and we would only depart from the text if there was an absurdity, and he defines it pretty narrowly, or, there's contradictory provisions, and otherwise, we look, if the text is unclear, we're going to look to the spirit, and we're going to look to things like purpose and structure. So there's a sort of, relatively straightforward or clear hierarchy. I'm not saying it answers every question there, and we can assess, what he's doing. I didn't really feel like that was discussed significantly in the paper. Now, a lot in the paper is about how, he talks about intent, and he's, not looking at the debates as if sort of, what the problem was that Marshall didn't channel Raoul Berger. But, I think the problem is that Raoul Berger didn't channel Marshall, right? That's not what they had in mind by intent, right? They had in mind something much more like purpose, something much more sort of hypothetical, and there's all kinds of problems with the sort of Raoul Berger version of intent. So I really think, in addition to his actual practice, there's the sort of statement of the methodology there that matters. He acts much more than our current Supreme Court justices actually he tells us what he thinks we ought to be doing, or what he ought to be doing. I guess my second point is, if you take an opinion like Marbury, right? So on the one hand, you can, or let me go back. If he says in this way that I've suggested that he's following what I would call originalist principles, and if there's a plausible argument that he's doing that, but at the same time we also think, hey, he's really interested in political results, and here's interestingly in Marbury, he doesn't get to the jurisdiction question until the end. I wonder why he did that. Well, he's got strategic reasons for that. Is then Marshall an originalist if he's engaged in such sort of strategy? Well, that's an interesting question. And I suppose the question sort of turns on why we're interested in it. But if you're interested in it as a kind of reflection of what was the legal culture at the time, then I think that points towards the fact that he's stating these principles and he's trying to defend himself in accordance with these principles really matters. It matters much more than our particular assessment of who Marshall was and what our view of him was. But it does tell us a fair bit about what he thought the legal culture was.
Larry?
Yeah, thank you for the paper. It's a really interesting and wonderful paper. Just sort of one comment about, so you quote me towards the beginning, so my view that it looks like our constitutional practice before the New Deal era was predominantly originalist is based on the work of Howard Gilman. That I had assumed before I started reading Gilman that it was predominantly non-originalist, and Gilman convinced me. But by the claim that it's predominantly originalist, I just mean to say that sort of blatant departures from original meaning, I'll talk about what that would be in a second, those are the exception, not the rule. So cherry picking history and finding some examples of everyone agrees that there are some non-originalist decisions, many non-originalist decisions, prior to the New Deal. It just doesn't answer the question as to what's predominant. Okay, with that out of the way, first, I really love your implicit critique of multiple modalities, constitutional pluralism, and the idea that without some hierarchy or decision procedure, this results in the will of the judge non-transparently determining the content of constitutional law. I thought that it was a devastating critique of constitutional pluralism. Second thing, and this is similar to one of Mike Paulson's comments, but I'm just going to spin it a slightly different way. So what would be required to show that a particular decision is inconsistent with originalism? And I think you need to take two distinctions into account. So first, the semantics pragmatics distinction. Lots of the stuff that you are calling sort of alternative methods or alternative modalities of constitutional interpretation are very relevant from an originalist perspective to pragmatics, right? To contextual disambiguation, to pragmatic enrichments of various kinds. So the fact that structure arguments or contextual arguments or arguments about purpose or teleology are made does not show that we're not engaged in the originalist textualist modality. It's just that we're in the pragmatic dimension, the pragmatic aspect of determining communicative content. Second thing, you need to distinguish between the interpretation zone and the construction zone. The use of, at least for those of us who believe there is a construction zone, the fact that things other than meaning are determining outcomes in the construction zone is no surprise, right? So you have to show that the issue or case that you're talking about is in the interpretation zone, that it's one where the text would, where the meaning of the text, the full meaning of the text, would determine the outcome, and then they did something else instead. And finally, you need to show that there are knowing violations of the constraint principle, right? It's not enough that someone made a mistake. You have to show that they knew, or that it's inferable, at least, from the things they said in the context, that they likely knew what they were doing and they were overriding the text. So I just don't think you have any examples that do all of those things, right? just third thing, one tiny comment about your discussion of Marbury versus Madison on page 56, and in particular, note 237. So I have a completely different reading of Hamburger than you do. I think Hamburger here is saying that the whole framing of Marbury versus Madison in terms of a power of judicial review, that is a modern projection, sort of a progressive constitutional theory projection on Marbury versus Madison, that Marshall saw this as a matter of judicial duty, a duty to apply the law. And I don't want to do it now, but I think if you go through the argument of Marbury versus Madison with Hamburger's reframing in mind, it turns out there's no ipse dixit. It is a perfectly sound, logically constructed argument that shows that the duty to follow the law requires that the Constitution prevail in cases in which it is in conflict with a statute. That's it.
Jeremy?
So I'm detecting a pattern. So I think, right? I mean, a lot of what you guys want to see in the paper is not there because I'm not trying to show that Marshall was not an originalist. And I am perfectly familiar with inclusive originalism. Big fan. My only point, and there are very plausible arguments that Marshall was an inclusive originalist. I get it. It's just that I don't think it's the best prism through which to read the jurisprudence of the Marshall Court. Because I assure you, if this were the 10th annual Living Constitutionalism conference, everybody would be saying, but look, there's so many examples. Show me one example that disproves the claim that Marshall was a living constitutionalist. Broadly construed, right? Inclusive living constitutionalism. I'm trying to set all that aside, and not come at the constitutional decision-making of the Marshall Court through that prism. Let's see. I have to think about not to convince, but to explain. Gee, I see a lot of convincing going on in Supreme Court opinions, but certainly as an ideal, I think that's a good point. In terms of Marshall gives us a hierarchy, I mean, I think he did that a couple of times, but in opinions written from the same year, he would ignore that hierarchy. Story sets it out somewhat similarly in the treatise, but also says that it's not really followed or binding, and I think that's you disagree, but I actually think that my reading is more accurate in terms of the diversity of the pluralism that the court actually engages in, and I'm delighted by Larry's characterization of my argument as a critique of constitutional pluralism. I think that's great. Let's see. And then I don't make the interpretation construction. I don't specify the interpretation construction distinction because I think all of these decisions, the ipse dixit decisions that I care about, are in the construction zone. Did you want to?
Michael, did you want to?
No. Well, I'm actually interested in why you are delighted by Larry Solom's characterization of it as a critique.
There might have been an implicature there.
Yes, I always
Because I kind of saw that as like, if you have multiple interpretive modalities, it gives way to just discretion, unconstrained choice, and it's disguised. And I thought that was a critique you were making, if not of multiple interpretive modalities, but of certain methods of originalism. But I didn't understand the irony.
So I didn't intend it as a critique, just a description, and I don't think it has the conclusions, as I've already said. Has the implications, as I've already said. That I still think there's lots of constraints, and there's room for good faith, ipsa dixit reasoning.
Our next trio, it's Tom, Chris, and Steve Sachs.
Okay, I'm afraid much of what I would say is redundant of others, so I'll try to say it slightly differently to make myself feel better. But one thing that I will say that I don't think has been said by anyone yet is not only I think it's a great paper, I think it's right. I mean, I think John Marshall was a Bobidian pluralist. I already thought that before I read this. After I read it, now I'm convinced of it. So you convinced one person, so there's that. My question was sort of on this notion, rather than come at it from a Will Bode, Steve Sachs inclusive originalism angle, I'll come at it from a Will Bode, Steve Sachs positivist account angle and suggest that the fact that these ipsa dixits where Marshall feels a need to say, well, the original intent just happens to be this answer that I want to produce for other reasons, but the fact that he filters it through that lens might suggest that it's bad originalism, but it purports to be originalism rather than coming out and doing what Mike said. Give me the example where he sort of says, okay, the original meaning is X, but screw X, I'm doing Y. The fact that he doesn't do that and that he hides his decisions, he brings all the other modalities in, but he seems to tie it all back around to, and this just so happens to be the original meaning, that, if we take the positivist account that something is originalist in the sense that it purports to understand the constitutional decision-making process as one that must be tied ultimately into meaning, maybe this is originalist in that sense, and to the extent that sense is important, maybe Marshall's is more originalist than you give him credit for.
So lots of super interesting stuff. I guess, and this is sort of a theme, there's a general puzzle about what you do when people have principles that they don't live up to. And would you say that, Jefferson, it wasn't an equality guy? Well, he said all men are created equal, and he didn't live by it. A couple of cases that I really think you ought to talk about, if you're going to look at the principles that Marshall enunciated, are his Ogden versus Saunders dissent and U.S. versus Fisher. So here's Ogden versus Saunders. Much too has been said concerning the principles of construction which ought to be applied to the Constitution of the United States. On this subject also, the court has taken such frequent occasion to declare its opinion as to make it unnecessary at least to enter again into an elaborate discussion of it, to say that the intention of the instrument must prevail, that this intention must be collected from its words, that its words are to be understood in that sense in which they are generally used by those for whom the instrument was intended, but its provisions are neither to be restricted in insignificance, nor extended to objects not comprehended in them, nor contemplated by its framers, is to repeat what has been already said more at large and is all that can be necessary. One thing that's quite striking reading your paper is that he doesn't state principles of interpretation that frequently. And that's a striking fact. When he does, he suggests that, well, everybody agrees. U.S. versus Fisher, I won't read that, but it seems that you've got to deal with his principles as well as kind of, what's going on in McCulloch, what's going on in Marbury, what's going on in kind of the big cases. When he gets to the point of stating principles, he states them this way, and the way an institution advertises tells you what it thinks its customers demand.
Steve.
So, you say that you're aware of the inclusive originalism debate. I'm not totally sure the point has gone home, just in that the opening of the discussion of Larry's definition says, if originalism is to have any bite, then Solom's two principles are key. I'm not totally sure that's true, given that we wrote the bite article and the, also, I wrote an article critiquing the principles. So it might well be that people could disagree. That's not merely you should cite more of my work. It's the point that there may be other things going on such that even a world without, fixation constraint, or with fixation constraint being contingently but not necessarily true, would still result in an awful lot of bite. And I think that this echoes the concern that others have raised is there an indication that this is really the Bobbidian or Bobbitaceous or whatever the right adjective is this really pluralism about the substance of constitutional law, such that the thing that is the Constitution is the product of a whole bunch of different factors? Or is Marshall searching for, an original law, say, as to which there might be a lot of different evidence? When we think about some controverted criminal case where there's dispute over whether something was in self-defense or not. We might have, video evidence, but it was grainy and a lot of stuff happened off screen, and we might have witness testimony and there's physical evidence and there are various inferences that we can draw from the various pieces. And, ultimately we might have some hierarchy of which types of evidence are more reliable for what, but a lot of judgments are going to be sort of all things considered judgments, but that doesn't mean that the actual fact of the matter is in some sense pluralist. Like there's actually things that we think either happened or didn't happen, and the different sources of evidence we might draw on, like Marshall says, you draw on whatever you can get when you're trying to figure out what a statute means, and you do the same thing when you're trying to figure out what happened in the fight. Now we wouldn't necessarily say that like a seance, or sort of going to a psychic will tell us anything useful. So we have some theoretical commitments about stuff that's just excluded that we're not going to look at. But it strikes me that the evidence that's presented in the paper doesn't really show ipse dixit so much as just the consideration of a whole bunch of evidence and finding some of it more plausible than others at various times. I guess what I'm really looking for is a hard clash between in one case, he finds this body of evidence persuasive. In another case, he finds that body of evidence persuasive in a way that sort of you couldn't do just based on actual assessments of the bodies of evidence that sort of actually require theoretical inconsistencies in his judgment of what's persuasive.
Jeremy.
So I think combining Tom and Will and Steve, I thought I understood inclusive originalism. Maybe I need to look at it again. I thought that I could reconcile your originalism with Larry's two principles. I hadn't seen your critique of it. You'll have to. I don't have to cite you, is that what you said? Okay. But again, right, if what I describe you want to call inclusive originalism, that's great, unless you want to mine Marshall for the purpose of finding evidence to support your theory. Then I think you're just doing it backwards. Let's just read Marshall and figure out what's going on there. And again, what I see going on there is common law statutory traditions of interpretation. And then I think that relates both to Chris and to Larry Solomon. So I'm somebody who likes to test people's principles against their practice. And of course, I'm familiar with those statements of Marshall's methodology, but I find them inconsistent with the practice. I don't think there was a hierarchy. And it's not a matter of it's not a matter of finding an instance where if you followed this methodology, you would have come to a different conclusion, because often it's a matter of, and of course, Marshall is skillful, he's a craftsman, all of the modalities always align for him, right? But when you look at the briefs, the arguments, the responses, you see that there are arguments that were within modalities that were certainly within his wheelhouse that he simply doesn't address in the opinion. And you can say that he just didn't find them persuasive, but they are arguments by fellow framers. They are argued at length. They have wide support in various, mostly Republican constituencies. It seems too important to dismiss them with a wave of the hand, and that is quite literally what he does. I mean, he says it's a proposition too preposterous to entertain, right? That to me smacks more of ipse dixit than reasoned argument.
When I think of the question, was John Marshall an originalist, it just seems to me in some respects an ill-formed question because, as you point out in the paper, on page 30, for example, given his own credentials, I'm quoting you, Marshall felt no need to consult sources in order to discern the framers' intentions. I think you can amplify that, and if we think a little bit about Marshall's lived experiences, so we have documentary records of Marshall's life, and his opinions first and foremost, but his correspondence, and you can mine the entire collected papers of Marshall and try to get a sense of what he thought. But you can also reflect on his lived experiences, and I just don't think we spend enough time thinking about this, particularly when we're addressing the kind of topic that you're teeing up for us. So, Marshall was a founder. Yes, we know he was at the Virginia Ratifying Convention, but also he knew intimately many of the framers. He was very close with Washington. He was Washington's attorney. Washington convinces him to run for Congress. Marshall spent several months in France during the XYZ affair with two men, Jerry and Coatsworth Pinckney, who were in Philadelphia. It's very hard to imagine that they didn't discuss the drafting of the Constitution. They had a lot of time on their hands. Marshall, was in the Virginia legislature when Kentucky and Virginia resolutions are being adopted, and if Kurt Lash is correct, he authors the Minority Report. He had fought the battles around the scope of federal powers at a very intimate level before he gets to cases like Fisher and McCulloch. In composing his life of Washington, and maybe Gerard can speak to this, I know he's looking at this body of material, Marshall gets from Bushrod Washington access to the Washington papers, which of course include documentary evidence of what happened in Philadelphia, like the Committee of Detail drafts, that nobody else had. He could actually sit and compare in a way that nobody else could, maybe a few people could, but very few people could, the final Constitution with the earlier drafts. And he could actually see what had happened and draw inferences about the purposes and the intentions of the framers. Therefore, he could say things like he says in McCulloch's shocking, to my mind, statement, if the framers were going to disguise either the grant of power or the limitation of power, they would have disguised the grant of power. That's a very natural inference to draw when you look at the drafting history and think about the final Constitution, think about the way it was sold during ratification. So I just think that Marshall is specially situated with respect to the founding in a way that arguably after the Marshall Court never happens again. I do think the early Federalist Court, people like Wilson, Ira Dell, they have that same intimacy or different kinds of intimacies with the drafting and so forth. But the question that we're discussing is salient to us in a way that is just not the same, I think, for Marshall himself. And there's a cleavage that occurs between the Marshall Court and everything that happens thereafter, where people do have to draw these inferences about framers' intentions and purpose of the document and some of the early political battles and what their significance was in a way that he just didn't. So I just sort of offer those observations up as a way you might amplify a point I think you're already making, and I think it would help support the broader point that you're making in the paper.
Fred.
So, Jeremy, you started off in your discussion by saying, as a historian. So, with apologies, I want to out you as a jurisprude, which you are also. And indeed, I want to out you as a jurisprude with particular expertise, knowledge, and insight about Kelsen. It may be one of the things that makes you particularly interested in the hierarchy among sources, which is a very Kelsenian idea. But more to the point, it also might lead you to the, at least for me, problematic conclusion that in choosing among non-hierarchically arranged sources. What Marshall is doing is, your word, extra legal. I'm interested in the designation as extra legal. Again, this is the way you put it is a very Kelsenian idea. Kelsen's wonderful metaphor of a frame without a picture is designed to suggest the idea that no legal result is exclusively determined by law, and all of this non-legal stuff is coming in. I wonder if you would talk a little bit more about why you consider it non-legal. Is it part of a larger view that the exercise of unconstrained discretion is non-legal? Do you believe that the discretion there is actually unconstrained? All of this suggests, at least to me, that there may still be something very legal going on, even if it is discretionary. It still takes place within a legal environment, with legal procedures, with everything else. And I guess my challenge a little bit is, why do you consider it, or question, why do you consider it extra legal? And I'll add a footnote to that, because I realize that this is not a group of people selected for their interest in the law of evidence, but back a couple of decades ago in Daubert versus Merrill Dodd, dealing with expert testimony, Justice Blackmun for the majority says, these are the various things that go into determining whether this is legitimate or reliable expert testimony or not. Justice Blackmun then says, here's a list. There might be other things that go into it, this determination, that I haven't listed. So it's not an exclusive or exhaustive list. Moreover, Justice Blackmun says, not everything that's on the list has to be used in determining whether somebody is an expert or not. Then Associate Justice Rehnquist goes berserk, and he says, in effect, a non-exclusive list of things that may or may not count doesn't help us at all, and although Rehnquist may not actually use the term, he in effect says, this is not law. So I wonder if you would just talk a little bit more about law and non-law in light of what some would call pluralism, what others would call just lists of factors, and so on.
Steve.
So this is not a completely unrelated vein, my question. I did want to say, I also enjoyed the paper a lot, and I actually found it, like Tom, quite convincing on the terms that I think you were trying to use, and with respect to the question that you say you were trying to address. And I'm taking you being perfectly sincere, and it seems legitimate to say that you're not trying to prove that Marshall was or wasn't an originalist, but you're suggesting that that isn't the most helpful lens, I think, your prism, I think you said, for understanding him, and also that you're trying to see this. You had that great quote from von Ranke, I can't remember, but look at the era, standing before God on its own terms, and something to that effect. So all that seems to me like a perfectly fine thing to do. And if you're trying to do that, it seems to me that it would be helpful to say a little more up front about what law in general sort of means today to the people who are raising these kinds of questions, and what law might have meant to the people of Marshall's era. It seems to me that might be quite illuminating. So I would say that today most people who talk about law, most people probably here, essentially in the background have a kind of a positivist assumption about what we even mean when we're talking about law. I didn't know you had a background in Kelsen, but I mean that would certainly support that, suggest that you yourself do. And if you have that kind of background, then you think that for the court to decide according to law, the law and the text essentially are the same thing, and for the court to decide according to law means for the court to decide according to the meaning of the text. And so then, even if you are not a positivist like Dworkin, you have to say that what I'm proposing are other ways of interpreting the text, Or, if things run out, you have to say, this is a construction zone. We're construing the text. And for you, I hadn't realized, but you may have the same assumption if you're saying, when Marshall did this, he was being extra legal. Again, this was ipsa dixit. It wasn't law when he did this sort of thing. But I wouldn't want to try to characterize the thinking about law in Marshall's time. I imagine it was complicated, but I'm pretty sure it was rather different than it is now. I mean, the common law would have had a different function then. You'd have Swift against Tyson saying things like, common law decisions are not law, they're just evidence of law. You'd have people saying similar things even about statutes occasionally and so forth. You'd have people saying all the time that Christianity is, the essence of the common law, and all kinds of things that don't make any sense, really, I think, to people today with more positivist assumptions. Now, if we could at least say that law was viewed in a much more pluralistic, normatively rich way at the time, then the questions might have different meaning, for example, and it might turn out that someone like Marshall could say perfectly sincerely, when we're reading the text, we care about what the words mean and what the intention was, what Chris Green quoted, things of that sort. And that would not be inconsistent with pluralism, now it might be better not to put it in interpretive modalities as if these are all ways of figuring out what the text meant, but they might be pluralistic in terms of understanding what the law is. So I don't know exactly how that would come out, but it seems to me it would be tremendously helpful to what you say you're trying to accomplish if you had more of that. Okay.
So to John, I just want to say there's a part 3 that due to the new draconian word limits, I had to cut out that had all of that stuff in it. I can say that because I had to cut it out. And nobody can say I'm lying. Fred, I can't believe you outed me as a Chalcinian in this context. I think you noticed something that I had not really fully confronted, is that I've sort of conflated in my head the difference between interpretation and construction with the difference between the legal normative realm and the non-legal normative realm. And I think you're right that really is what I mean by extra legal, and I'm thoroughly Chalcinian in that way. And I think that's my response to Steve as well.
I will just make this suggestion. Michael raised the question, does it matter that John Marshall was an originalist? I think you are right that at the Living Constitutionalist Conference, various living constitutionalists would say he's a living constitutionalist, just as here, right, up until we got to Steve, various originalists say, whether they think it matters or not, that he is an originalist. And so I just want to suggest, maybe you're right, it matters. Because people seem to want to answer the question by saying he's one of me. So if we think, and Michael's argument of why it doesn't matter is completely coherent on its own terms, it might not exhaust the ways in which things matter in this business.
Ian.
I want to fully endorse what both Fred and Steve said, and stand up a little bit for the multiple modalities approach in this sense that I think the modalities are the question of what is law, not what is the text. And I think that the situation that occurs where you have the conflict modalities and what you call the ipsi dixit, I think ipsi dixit is uncharitable because I don't think it is unconstrained. I think there is a set of constitutional values that inform what are the permissible range of options once you're outside the modalities. And I think this is the same circumstance that Thomas Kuhn confronted when he said that you can't get from one scientific paradigm to another, right, within the grounds of the original paradigm. And everyone said, well, then you're ruining all of science, right? It's no longer science. He said, no, there's still a core of scientific values which we use to justify the transition from here to there. And I think that's what happens in constitutional decision-making at that level. We have a set of constitutional values. We go to that. And I think that's what Marshall did, and I think that's what every judge does. So I think you could be much more charitable in that description of what that process is.
Mike?
Yeah, well, some of the things that I was going to say have been touched on by Mike Paulson and others, and then we've gotten well away from that. But I sort of want to bring it back because I guess at this point I've gotten a little confused as to what the central thesis of the paper is. So you said at one point that you're not saying that Marshall is not an originalist, but I wonder that aren't you saying that, and why not if you're not saying that? But I was looking at page 11. You say that the justices did not use anything like a contemporary originalist approach, right? Which, and then the next sentence is rather they consulted sources of authority other than the Constitution's original meaning. And so that sentence in particular seems to me to raise the question of what does it mean to consult authority other than the Constitution's original meaning? That is, what is the category of things that you consult when you're consulting the Constitution's original meaning? And I guess I would like to see some further explanation of this, because it then seems to me that a number of the things that you talk about, Marshall and Story, using are actually things that I would consider, and maybe this is just an inclusive originalism point, but I'm not sure that I'm an inclusive originalist. I'm sort of a little exclusive on things here, at least, but nonetheless, I'm not really troubled by a number of these things. The structure and historical purpose or intent, or even the fundamental logic of the Constitution, don't seem to me things that are far off from what even a modern originalist would or might consult. And then I think there's a separate category of talking about precedent, which, although I agree that precedent is not necessarily a central tool of originalism, nonetheless, it is something that is regarded as compatible with originalism by at least a number of originalist theorists and judges, although not anyone sitting at the front table. There are, I guess maybe you need a category of things that are in and things that are out. I do think, by the way, just parenthetically, that if you were making a more narrow claim, which is that John Marshall was not an original public meaning originalist, more of those things that I recited might well be on the outside as opposed to on the inside. But maybe there you want to engage some of that and some of the differences among originalism, because I do think as has been said at this conference before, that originalism is a family of theories, and some of those theories are going to include a lot of the things that you talk about Marshall doing. So then my last point is the next sentence in that paragraph, the last sentence in that paragraph, is often they, that is the justices, consulted their own non-legal, political, pragmatic, or theoretical commitments. Now, I really like this sentence, because this seems to me to be now setting out the category of things that are not permitted by originalists. And I think this is right. I think those are things that are not permitted by originalists. So that really sets the standard, or sets the test for what I at least took you to be claiming before the discussion of the last half hour. But then I question whether you actually deliver on that sentence. Because what ensues is a lot of discussion of Marshall using structure and speculation about framers' intent and so forth, some of which may be indeed wrong or bad argumentation on Marshall's part. But I don't think that makes it not originalist, and in particular, I don't think it makes it non-originalist by putting it into the category of things that you list out here in this sentence, which I think is indeed the right test. But now I guess I'm not seeing whether there are things that fall systematically. Again, one instance or so it wouldn't do it, but it's systematically into those categories. So to wrap it all up, I guess my question is: are you indeed making the claim that you appear to be making in this paragraph? And if you are, what do you regard as your strongest evidence for it?
So it's funny, Richard and I had a conversation last night in which he said, you don't have to clarify why Marshall matters. Everybody knows Marshall's important. And then Michael starts out by saying, who cares about Marshall? And I think you're both right. As I tried to point out in my introduction, Marshall may not matter to a lot of originalists. It may not matter whether or not Marshall was originalist. It matters to me because I'm trying to write a book on the history of originalism, so I need to figure out what chapter 1 is going to be, right? And actually, it's chapter 1 is theory, but chapter 2, and apparently chapter 1 is all going to be about Kelsen now. But anyway, there's that. Then both Ian and Fred brought up this notion about lack of constraint. And again, I still think I see lots of restraint, despite the fact that I think ipse dixit reasoning is going on. And again, it's related to the fact that what I regard in my Kelsenian mode as non-legal normative systems still apply. So logic still applies, although logic is part of Kelsen as well. Right? Prudence matters. Morality matters. All of that stuff, I think, constrains. I think the culture of the court matters as a restraint. I think they care about what their colleagues on the bench think. And of course, farther down the road, the precedent becomes increasingly important mechanism of restraint. So Mike, I think you're right that I need to really stress more the instances. So the first part is I recognize that originalism is a family of theories, and so it's very difficult to point to. It would be a huge project and one that doesn't interest me because what I'm saying is let's not look at Marshall through the lens of originalism. It's not productive. It's extremely difficult because originalism means so many different things, and so I think the first quote that you pointed out, where I say it doesn't look like any recognizable version of contemporary originalism, that was sloppy on my part because so much of contemporary originalism sort of bleeds into to living originalism or something like that. But still, I think I should bring home I should have stronger examples or point to the examples where he's clearly engaged, or the Marshall Court is clearly engaged in non-originalist methods. I think one obvious example, it's not dispositive, but he says, like, whether, we can't just ignore the fact that a bank existed, right, in McCulloch v. Maryland. That he seems to give a lot of significance to that weight, to that historical fact. I'm always afraid to bring up Stewart v. Laird because it feels like people don't talk about it. So there must be something out there that I'm missing. But it's such an obvious case of the court just saying, we all thought it was unconstitutional to force us to ride circuit, but they did it, so we're moving on, which strikes me as an example of something like living constitutionalism right there in 1803. So now I understand, right, Larry's point is that originalism was the predominant approach, and so maybe Stewart v. Laird could just be dismissed as an outlier. But, I'm trying to think about all of the different modalities of originalism that are out there, and I think Stewart v. Laird is an important problem for original methods originalism, because if Stewart v. Laird was one of the modes of interpretation that was around at the framing, or certainly by 1803, then something that looks an awful lot like living constitutionalism is part of original methods originalism.
Stewart versus, you shouldn't read this into Stewart versus Laird because it was not a real opinion. It was they were capitulating. Their teeth gritted the whole time. They didn't believe a word. It's a parody of an opinion. They didn't want anyone to agree with it because they actually took the opposite view, and they knew that if they said what they meant, they would get impeached. So it's a really great, interesting case, but don't read it for real constitutional interpretation. Second thing is a suggestion that this should have a different name. Your name for it is Chapter 2. It ought to be Chapter 3. And Chapter 2 ought to be about the earliest constitutional interpretations, which weren't in the Supreme Court, but were in Congress. So you ought to look at the removal debate and the post roads debate and the lighthouse debate and the Pacificus Helvidius debate and the Sedition Act debates and the quasi-war debates over the quasi-war with France, and see how much originalism there is there.
Can I just jump in? You should also look at the pre-Marshall cases. So, I mean, there's a whole body that I've written about of pre-Marshall cases, which some are intentional, some are originalist, Patterson and the carriage tax cases, but they're largely structural. So that's, I think if you're going to do a Chapter 2, I would add that.
We here are constrained by our structure, which is concluded now. Thanks for a very interesting paper and a lively discussion.